Article 13, the clear and equivalent terms lays down all law, including precondition law, which is in constant with the derogation of the fundamental right guaranteed by the Part 3 of the void. Article 3 brings into the fold of laws all rules and regulation, notification, customs, usage being the force of law. Adi Shivam Shivacharyagalu Nala Sangam Sangam was the government of Tamil Nadu. The main objective of Clause 13 is to secure the paramount of Constitution in regarding fundamental rights. The first clause related to the laws already exist in the force and declares the pre-constitution laws are void to the extent to which they are inconsistent with the fundamental right. The second clause related to the post-constitution law prohibits a state making a law which is either law takes away the total or arbitrage parts of its fundamental right. The expressing the state, which is a construed in conformity of Article 50 and judicially interpreted. The ambit of the expressing law is defined in Article 13 itself, and so is ensure the paramount of constitutional liberty. Temporary laws, such as ordinance and act as well as permanent laws. The statutory instructions in the nature of subordinate and legislation specifically describes order, bylaw, rules, regular notification, which is the territory of law, the force of laws. Non-legislative source of laws, that is to say, customs and usage have the territory of India of force of law. The objective of the definition of Article 13 is to ensure that the instrument is embarked from the source of law. The permanent or temporary registration or judgment or something other will pay a homage of institution provision relating to the fundamental rights. At the same time, clause seeks to ensure that constitutional amendment does not fall within the definition of the law of Article 13. Its validity cannot be challenged on the ground of the whatever its fundamental rights. But it should be noted that a fundamental right is such a while not immune from the constitution amendment says the same clause a part of the theory of basic features. Education. In certain decisions of Supreme Court, the chronology of the importance of Supreme Court decisions in the subject was L.C. Loknath, Sub-Government State of Punjab, Keshavananda Bharati, Sri Padma Garua, which is State of Kerala, Minerva Mills. So the Kerala, which is upholding the validity of Constitution with Article 13.4 inserted light down the area of which a certain basis features which could not be amended under the amendment power. Now, Merava Limited Union of India, which describes that even though the 42nd Amendment is showed to be Amendment Act 368, there will be no limitation whatsoever on the Constitution power of Parliament to amend the way of addition, variation of repulsion, provision of the Constitution, Article 365 Constitution Amendment, which is related to the basic feature, total exclusion of judicial review. Exclusion of judicial review, okay, would be wide. And Vaman Rao is Union of India, paragraph 15, reaffirming about the litigation on the constitution power. Behim Singhani is Union of India, S.P. Gauta Union of India, and doing was addition which is upholding the validity of particular amendment, implying the proceeding of prosecution. This constitution amendment cannot be override the basic feature. Farman C. Shakti in law. Farman E. Shakti is a decision taken by the state government which carried out the force of law within the meaning of Article 13 Constitution State of Punjab with Mahatkari Das Chal Mahat Marnon Das Patel. Act of Parliament. The doctrine of the basic feature of the extent of Constitution does not apply to the ordinary legislation, which has only a dual criteria to meet. It must should related to the matter within its competencies. It should not be void on Article 13 and being unreasonable restriction on the fundamental right of being replicant. Replicant. To express the constitutional prohibition, basic structure theories imposes a limitation on the power of Parliament to amend the Constitution. The amendment of Constitution under the 368 would be challenged on the ground of violation of basic structure of Constitution. An ordinary legislation cannot be challenged. Kuldeep Nyayar, Union of India. Art of State, the state of Haryana, Hamar Nag Bansal, and the RIR 1984. It has been held that the result of the covenant covenant. Covenant, which is a covenant, and therefore it's an act of state, or entered into the roots of a state which is established with a new sovereign over a territory expressed in the state of rulers. The covenant is therefore an act of state which is regarded as an act of state. The law is entered. The resident of the territory which is acquired to be do not carry out this right, a right which is being possessed, a subject of the object of exclusive sovereign. A subject of a new sovereign, they possess only such a right as a granted or some recognized by them. Basic feature. The basic feature of the constitution cannot be amended by the existing. The basic feature cannot be amended by exercising the power of Amendment 368 Constitution 42 Amendment, which is inserted in 36385 provision. There is no limitation on the constitution power of the Parliament to amend the Constitution. It has been invalidated by the Supreme Court adhering adhering to the doctrine of basic features. Doctrine. Though the fundamental right is not immune to the amendment of en bloc, articular rights and parts therefore may be held in basic features if the undermentioned cases. Kesavananda Bharati, Sri Padmanabha State of Kerala, Minerva Mills Limited Union of India, Vaman Rope Union of India, H.S. Srinivasa Raghavara State of Karnataka. Interpretation. The court has depended on the literal interpretation, so the provision became constitution if the literal interpretation makes provision of unconstitutional. Indra Das was a state of Assam. Severability. In a particular provision of enactment, it is found to be void and violating the constitution provision. Severability. C-V-R-A-B-I. Severability. The question must be arising as to what is the impact on the finding of the other provision of that. The answer is the question depends on the answer of another question, namely in the other provision so intimately connected with the void provision, and that each is inextinguishable to bond up, and to which is the. It can be assumed that legislature which is would have not been enacted to one without enacting other. The right answer is A or above. Both affirmation that when the other provisions became void, you see the mention above. The state of Bihar, Kameshwari Singh, AR 1952, and Jalan Trade Company Mills Mazot Sabab, and Zigdora Holahon, which is Zikhilo. Constitution Amendment is a declaration of unconstitutional Amendment Act Revolution. 17th Amendment LC Loknathik State of Punjab. 21st Amendment Keshavananda Bharati Sri Padmavali State of Kerala. The 32nd Amendment Sambhavati is Union of India. 36th Amendment Indira Nehru Gandhi is Raj Narayan. The relevant of Article 329A was repealed by the 44th Amendment. Article 368 Minerva Mills Limited Union of India, and 52nd Amendment Quixote hold on with this Zakulu. Treaties of the Human Rights. The most remarkable institution developed by the human rights has been evaluated by international multilateral treaty regime. This is an appropriate monitoring body. At the time, only a previous World Conference on Human Rights had held on Tehran in 1968. Not a single human rights treaty body existed. By the time of the World Conference in Vienna, several treaty bodies had come into existence under several treaties, namely International Covenant on Civil Covenant, C-O-N-V-C-O. Covenant, C-O-V-A-N-A-N-T. Covenant of Civil and Political Rights, 1997. International Covenant on Economic, Social, Cultural Rights, 1966. The Covenant of Eliminating All Forms of Racial Discrimination, 1966. The Convention of the Suppression of Punishment of Crime of Apartheid. And the Convention of Suppression of Punishment of the Crime of Apartheid, and the 19th Convention of Elimination of Discrimination Against Torture, Convention on the Rights of Child, Convention on the Rights of Child, 1918. At the time of Vienna Conference, 168 states or parties which are treaties are all collective monitoring procedures. The wideness of existing laws. Clause 1 of Third Class Article 3 provides that the existing law which is clashes with the exercising of fundamental rights conferred with the Part 3 of Constitution shall to the extent be void. Case Savananta, the State of Bombay. but they are not void ab initio. Existing block which is inconsistent with the provision of Article rendering void only affecting the commencement of the Constitution. D.K. Nabli Rajit with the state of Mysore, Pannalai Beni Raj state of Union India, Rabindra Union of India. Inconsistent with the Supreme Court can stroke down the law only if there is a clear constitutional violation, not merely because of falling into disuse or because of the perception of society has changed regarding the legislature or purpose of need of law and costume. Suresh Kumar Kaushal with his NAC Foundation, working of act. How an act has been working may be looked as by the assessing validating. Charan Lal Chowdhury with his Union of India. My right to equality, equality of law. The state shall not deny any person equality before the law of equal protection of law within the territory of India. Promotion, merit cum seniority. There is a sharp distinction between the merit cum seniority, seniority cum merit. In such a case, a merit has to be given preference over seniority. UP Mahathkar, which is Subhash Anand Charan. The administrative decision should contain all the reason which prevails official decision to arrive on the conclusion of no authority, merit cum seniority. Administrative decision that contains all the reasons which is prevail on the official decision to arrive at the conclusion no authority can be permitted to travel beyond the state adopted and expressing by it to implement on action. The state of Punjab is Pandip Singh JT. Comparative appointment. The comparative appointment cannot be granted on the post for which the candidate is compassionate appointment in which candidate is ineligible. Rajasthan State Road Corporation versus Ravan Singh. A legitimate expectation. The doctrine of legitimate expectation cannot be applied in the case of invalid expectation. State of Uttar Pradesh is Union Bank of India. Doctrine of proportionality. Determination of final cost of land as dispute shall be in consequence with the doctrine of proportionality, but not on the basis of market price, but which is arbitrary and unfair. Madhya Pradesh Housing Infrastructure Development PS Bardar. Judicial review. Judicial review to justification only in the government policy is arbitrary, unfair, and violated our fundamental rights, and the court must be to venture into the evaluation of state policy. Further, the policy proves to be unwise and oppressive to mindless electorate house to quick to make an electoral government of a Kerala Bar Hotel Association State of Kerala. Breach of fundamental rights. In case of breach or illegal denial of admission to a meritorious student, and monetary compensation cannot be adequate as sane relief because a depreciation affects depreciation. Depreciation affects the academic career of students. Krishna Sharta was state of Andhra Pradesh, and the case of Chandra Chadishkar admitted to the Jasmine Karur. The Supreme Court held that this compensation and adequate relief need to be decided by the larger bench in the of S. Krishna and Shankar case. Equality of doctrine. Once it found there is insufficient material for taking into particular policy decision, bringing into within the four corner of Article 14 of Constitution, the power of judicial review would not extend the doctrine of correctness of which a policy decides on the Indians into the exercise of finding out whether there is a suitable alternative. Parish and Agrotech Union of India. Pension. The pension is not an ex gratia payment but an recognition of past service. The discrimination cannot be made between the employees directly appointed and absorption allotted, and by fixing a cut-off date of the purpose of computation of qualifying service. A.N. Shakdeva is Maharishi Dayananda University, Rohit, and KJS Buddha Union of India. Statutory rights. There are rights stand established in Article 14. Court shall have no difficulty in enforcing such a right, whether it is statutory, fundamental, or constitutional right. Raju Prasad Sharma, the state of Assam. Promissory estoppel. The rule of promissory estoppel is invoked only it is on the basis of representation made by the government and the parties substantially altered the position. State of Kerala versus MS Kerala Earth and Minerals Limited. Grant of mining license. If the existing rule at the time of tender, auction, or allotment of lease was providing terms of lease only for 5 years, and it was so provided in the allotment of attacks, and so subsequently allotment providing 10 years, provided the lease was substantially provided first time, creating a new right for the prospective allotee. Hence, it cannot be termed only for procedural provision, and the allotee cannot claim any benefit on the same. District Collector Velo, District K. Govindaraj. Seniority and high pay head scheme. Post in a higher scale pay is permitted on the basis of seniority, not on the subject of inter-C seniority. Inter-C seniority. Inter-C seniority. In respect of the post of lower scale of pay, it cannot be addressed in the arbitrage and discretionary. 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 Mandol Kavanda Shah Bros Union of India, Union of India is Colonel G.V. Kevin. Allotment of industrial good. Even condonation of delay. Condonation, okay, condonation. Condonation of delays of acceptable respond party, then the corresponding can be cancelled, allotting the plot. Andhra Pradesh Industrial Infrastructure Limited versus MS Shivani Industries. The policy of no work, no pay. The principle of no work, no pay will not be followed where the authority is in fault of not considering the case of the employee for promotion and not allowing him to work on the promotion post. Ramesh Kumar versus Union of India. Government contract. The employer is not bound to accept any lower bid and award the contract. It is assessed the same in comparison to the marketplace and the previous contract. Comparison of the market price and previous contract. South Delhi Municipal Corporation Ravindra Kumar. Grant in telegraphic license. The distribution of license is subject to provision of Article 14. The Constitution of India. Such a discrimination must not be on the basis of the social rational policy. The application of government follows the Constitution as well as law. Bharati Airtel Limited, Union of India, and the Center of Public Interest Registration, Union of India. Union of India Associated Union Telecom Service Provider India. Post of Judiciary. If suitable candidates are not found, the employer is not obligated to fill up the post. Center of Public Interest Litigation is registered Central High Court of Delhi. Admission to medical college. It is the candidate deprived of admission of medical course due to the fault of medical college. Admission cannot be granted after lapse of cut-off date. Then the medical college is liable to pay compensation for him or a loss of 1 year of his career. Yes, Nihal Ahmed Deshu Vallamal Medical College Hospital is such an institution. Chhattisgarh administration is Jasmine classification now based on the medical categorization. The classification based on medical categorization is not singularly dependent on the percentage of disability suffered by the candidate. It depends upon the factors GST, Chaman Law, Union of India, Delhi and Latches. If the selection of the post of constable is challenged without impleading a selected candidate, then such petition has been dismissed for non-implementation of the last day appointment of candidate Ankiti Yadava, Central Administration Tribunal, Chhattisgarh. Seniority in the service jurisprudency. What? GURISPUPRU. DNC. The right of employee in relation to seniority is a vital one. And D. Vishnu Murthy of State Government of Andhra Pradesh. Right of OBC category candidate. The candidate of the category, the candidature of candidature. What's candidature? Candidature of a candidate cannot be rejected on the account of the late submission of the caste certificate or the post of staff nurse. Ramkumar Jiroja versus State Delhi Superordinate Services Selection Board. Now, wrongful deprivation of works and duty. The doctrine of no pay work, no pay will apply if the employees fail to prove that he or she remains unemployed during the wrongful denial work to her or the employer. Common cadre in services merely because of the incumbents of two posts. Incumbents. Incumbents of two posts are placed in the same scale of pay but does not determine the post constitute on a common cadre. Cadre. And the Union of India is called Colonel P.K. Chowdhury, and the Monel is part of Energy Limited Union of India, state of Uttar Pradesh, and Bharat Singh. Action of the state. The state action must not be arbitrary and discrimination. It should not be guided by any extraneous consideration which is opposed to equality. Senior Divisional Commercial Manager, Indian Railway Catering and Tourism Corporation, this is SCER Catering. And Chowri Choran and Union of India, Lal Rama, which is Union of India. Price fixation on natural gas by government. The price fixation respect of the natural gas, etc., is a policy designed by government. Hence, there is no such discrimination as it is applicable to all buyers within the same category. ESA Steel Limited Union of India and KCCR and and Association of Natural Gases Union of India also. See also Jaipur Development Authority, which is Vijay Kumar Data. The Equal Protection Law, Article 14 Constitution of Law mandates that state action must not be arbitrary and discrimination. It must also not be guided by any of the extraneous conditions. Consideration which is antithetical and antithetical to equality, and a senior division commercial manager, this is SCR cattle, dry fruits, juice stalls, welfare association. The equality of before law and equal protection of law is not limited in its application to the realm of execution action. It is available to respect of proceeding before the court and tribunal, but the law is separate to the interest of administration justice. And Kushwa and Pushan Sohan. Administration order. The reason must be stated in the order or official file contemporaneously maintained. Contemporaneously. Maintained at East Coast Railway with Mahadev Apurao when allegation of the malfeasance. Malafide are made by the person against whom the same was revealed, a level and a level need to be pleaded as parties, and proceeding to enable them to answer the charge. Ratnagiri Gas Power Company is a RTA Project Limited. Admission in a college and reservation for applying LLB course in Department of Law, Punjab University. Reservation of seat for employees of the university and the ward was unconditional. It has no reasonable nexus with the object of selection. When the object selection and the Praveen Hans was registered, and such a reservation cannot be made on the measure of welfare following decision. Prasanna Dinkar Show with the director in charge at Lakshmi Narayan Institute of Nagpur, Ajay Kumar Chandrashah Administration Union Territory, Chandrashah Ajay Kumar Mithal Haryana Agriculture University, Ashwin Dir Karur Punjab University, Pencil Sharth Kumar Dosi, State of Madhya Pradesh.